We will call to order the Board of Election Commissioners for the City of Chicago, constituting ex officio the Electoral Board to hear and pass upon objections to the nomination papers of candidates for office to be nominated or elected at the March 17, 2020 general primary elections. Good morning, my name is Marisel Hernandez. Seated to my left is Commissioner Jonathan Swain, and to my right is Commissioner William Kresse. Next item on the agenda is a Rule 20 hearing before us. 20 EB RGA-019 Andre M. Capetti versus Ricky Gandhi, representative in the General Assembly, 32nd Representative District, Democratic. Can I get the appearances, please?
Michael Casper, K-A-S-P-E-R, on behalf of the objector.
Andrew Finzo for the candidate, Ricky Gandhi, G-A-N-D-H-I.
Thank you. And Mr. Casper, I believe this is your Rule 20 motion?
Yes, it is. Thank you, Madam Chairman, members of the board. Good morning. I'm waiting for. Oh, I'm sorry. I'm waiting for a copy of one of the exhibits. So, see where that is.
She's at the photographic.
If you don't mind, I'm gonna reference one of the exhibits during my presentation. Thank you. Madam Chairman, members of the board, if you're ready for me to begin, I can. And I'll be fairly brief. I filed a Rule 20 request to appear before you in writing, where I take certain exceptions to the hearing officer's findings and recommendation. This is an interesting case. It's a residency case. The candidate is seeking the office of representative in the General Assembly. The Illinois Constitution provides that a person is ineligible to serve in that office unless they have been a resident of the representative district for 2 years preceding the election. 2 years under the Illinois law is measured from November 2020. So the candidate must have been a resident of this district beginning no later than November 2018. The facts show no dispute that the candidate lived and worked at a full-time permanent position until August of 2019, almost 1 year into the 2-year durational residency requirement. The candidate is a 28-year-old man who has graduated from college and graduate school here in Chicago, moved to Washington, D.C. to begin his career. He began with a series of internships and fellowships in 2015 and has stayed there and lived there on a full-time basis ever since, and moved back to Chicago in August of 2019 when he quit his permanent full-time job and moved back into his mom and dad's house. He has no ownership of any property in the 32nd Representative District and never has. He has never rented property in the 32nd Representative District. He has never sublet property in the 32nd Representative District. He owns no furniture in the 32nd Representative District. The furniture is in his parents' house. It's the bed that he slept in when he was in high school. So I think that the law is pretty clear that a person, a fully grown, emancipated man who's lived outside of the representative district for the majority of his adult life is no longer a resident at their mom and dad's house. He's 28 years old. The theory that the hearing officer adopted was, well, if he could claim residency in his parents' house when he's 28, he could do it when he's 38 or 48 or 58, just because he didn't change his voter registration. And that, I don't think, is supported by the law. And the law on this question is fairly well established. Commissioner Hernandez. I think you were the only one who was here during the case that we had regarding Mayor Emanuel. And the Supreme Court sort of set out what the law is. Residency is established by physical presence and intent, and then residency is surrendered based upon abandonment. And abandonment is shown not only by the candidate's words, but his deeds as well. And the deeds are more indicative than the words. Obviously, the candidate's going to testify, yes, I wanted to come back and run for office in order to meet the qualification. It's just self-serving testimony. But the more important thing, it seems to me, is what were the candidate's words at the time? What did he say when he was in Washington, D.C.? And that's what Exhibit 4 says. On the left-hand column, this is in 2014, I'm planning on a PhD. This is the candidate. The blue is the candidate type. I'm planning on a PhD after working for a few years, working in D.C. for a few years. PhD, where is that PhD? He didn't, when I cross-examined and when I examined him, he admitted he never actually did pursue a PhD. He thought about it, but he never applied. It shows someone with not a real firm intent. But more importantly, on the right-hand column, down at the bottom, there was some talk about him going to travel to Europe for one of the jobs he was in. Quote, D.C. is indefinite. Indefinite. As I said in my Rule 20, indefinite means undefined. Could be tomorrow, could be 10 years from now, could be 20 years from now. In order to show you're a resident of a representative district in Illinois, you have to have intent. And the word indefinite shows a lack of intent. The hearing officer completely ignored this exhibit in his report, didn't mention it at all. It's the dispositive evidence. How can he have intent to return to Chicago from Washington, D.C. if, in his own words, the amount of time he's going to spend in Washington, D.C. is indefinite? It just doesn't make any sense. And so I think that this evidence right here shows his lack of intent. Or he doesn't know what he wants to do. He's a young guy. Sure, of course he doesn't know what he wants to do. I didn't know what I wanted to do when I was that age.
Can you clarify the back side of that what's called that text? It says DC is indefinite, but probably a few years.
Yes.
What was the? Did you inquire about that?
Yeah, I asked what probably meant, and that means probably, right? Probably a few years, right?
Yeah.
And so, and I asked him how many years, and he didn't know at the time. That's what that was.
But I guess the question is, did the few years reference his time in DC?
Yeah, I think that's what he was talking about.
So there's a contradiction between indefinite and a few years, right?
Well, probably. I don't think it's in. I think both show that it's undetermined.
Gotcha.
Right. And now let's go back and talk about, contrast this with the case involving Rahm Emanuel. Rahm Emanuel had one job in Washington, D.C. during the residency window. That for mayor, it was a one-year residency window. He was White House chief of staff. He owned a home in Chicago. The candidate doesn't own a home here.
Could Mr. Emanuel sleep in the home that he owned in Chicago?
Could he sleep in the home?
Yeah.
I don't think so. He rented it out.
Yeah.
He leased it out. Yeah.
Didn't his tenant file an objection against him?
It was $10,000 for mayor too. Yeah. I don't know who his election.
Can we put you under oath for that?
Yeah, sure. I don't know. There are certain questions I didn't ask. And the other thing that was different and dispositive, I think, in this case, is that in Mayor Emanuel's case, he had witnesses come forward who said, yes, when he was in Washington, he told me of his intent to return to Chicago. There's none of that here. No witness, no writing, nothing from the candidate saying during any of his time in Washington, he intended to return home. And why? It's just not a credible statement. I mean, he's a 28-year-old man with a master's degree who works as an economist at the U.S. Senate. Do you really think his ambition is to return home to his parents' house while he's doing that? That's what he thinks he's gonna do, go back and sleep in the same room he slept in when he was in high school? And what evidence did he have? And Mayor Emanuel had all of these sentimental things. His wife's wedding dress, the children's clothes, all that kind of stuff was in his house.
Bedroom, right? He had his
Yeah, and his
bedroom.
PlayStation. Oh, for crying out loud. Right? He's an economist for the US Senate, and his evidence of his residency is his PlayStation?
I think we're talking about different generations,
Yeah.
and what, I
Right.
think what's interesting, Mr. Casper, is you referred to him at one point as a 28-year-old man, and then at another point you said, well, he's 28 years old. I have a 27, 31, and 32-year-old, so I understand. I think these millennials and living at home, but go ahead.
Yeah, the point is that the evidence showed that he was trying to convince the hearing officer, and I guess it worked, that he was still a high school kid. And he's not. He's a grown man who's worked as an economist in the US Senate.
So is your argument then that, just so I'm clear, is your argument that he established residency in his parents' house and then further abandoned it? Or are you saying that he never established residency in his
Yeah, he abandoned it when he left and went to Washington, rented an apartment, paid rent, and worked full-time in Washington, D.C. and
All of
slept.
which is the same as Emmanuel. Continue.
Yes.
Though there's differences, though.
Continue to show the differences, yes.
Okay, well, let me go on. All of the traditional indicia of residency support a conclusion that he lived in Washington during this period. His pay stubs went to a Washington, D.C. address. His charge card, his credit card, was billed to his Washington, D.C. address. His bank statements were listed with Chase at a Washington, D.C. address. I asked for his Uber records. He had several hundred Uber trips during the residency window. 2 were in Chicago, 2 were in the 32nd Representative District, 2. And all the other hundreds, and by his own admission, he was in Washington, D.C. overwhelmingly. The difference between this candidate and Mayor Emanuel is that Mayor Emanuel owned his own home. He had a residency. What happens if this candidate's parents sell their house and move out of the district? He's out.
But that's not the facts of this case.
I know, but so what? But that's possible,
Where was he
right? That shows that
registered
he
to-
has a lack of interest.
Where was he registered to vote?
He stayed registered at his parents' house, and I believe he voted illegally.
At what age can you no longer claim residence at your parents' house?
It's not an age thing; it's a behavior thing. I think you can no longer claim residence at your parents' house when you rent a house or rent an apartment. You get a full-time, not an internship, not a temporary fellowship or a full-time professional job in another city.
Is chief of staff to the president a full-time job?
Sure. Yeah, I mean, but there's a difference. The difference is that Mayor Emanuel had his own ties.
To a home you couldn't sleep in.
But it was still his.
But we're also looking at the realities of a 28-year-old who's starting out, and what financial ability does that person have to buy a home here? I mean, are you saying that is a requisite to finding whether or not a person can establish residency?
No, not at all. I don't think it's a totality. If this candidate had stayed in his high school bedroom the whole time, no problem. Certainly, you can live in your parents' house, I guess, until your parents throw you out, like mine did.
Well, that's understandable, but
Right.
from this, I'm wondering, what else do you have? I'm looking for some unambiguous evidence that he intended to permanently abandon residency in the district.
Okay.
I see suggestions, but I don't.
Okay.
But I mean, you even have in there. I can't wait to be back in Chicago, indicating he want. I don't see a statement. I'm giving up on Chicago and the Burbank and I'm out of here. I'm never returning. I don't see that.
Right, and nobody says that, right? And what it is,
Oh, I've
it's
heard it
measured,
said, but
measured
go
by
ahead.
your behavior, right? He testified, he got this job, a full-time job, not an internship, with the U.S. Senate as an accountant. And he testified that the job was depended on the elections, like most political jobs, right? We'll see what happens. The midterm election came in 2018. He was asked in November of 2018, after the midterm election, so during the residency window, he re-upped his position with the U.S. Senate. So he doubled down and said, I'm going to stay even after the residency window opened. So he decided to continue to work. Affirmatively, that's in the transcript. He decided to affirmatively continue to work for the U.S. Senate in November or December of 2018.
So-
That is not showing intent to return to Chicago.
So let me ask this, Mr. Casper. It seems as if your argument turns solely on the fact, and from what I'm gathering here, on the fact that this gentleman did not have any kind of contractual relationship to a piece of property in Chicago.
No, that's not it at all. It's the totality.
I understand, but what I'm saying is, I mean, when you, at least in my opinion, when you take the rest of the facts, they could be analogized similar to the Emmanuel case in terms of having a job in D.C. Okay, so it's a short term, it's a long term, all those kind of things. I think those are similar in my opinion. The one thing that you highlighted as the key difference is the fact that Mayor Emmanuel had a piece of property that he owned in his name that kind of gave him an anchor or stake, if you will. And that in this case, because you keep referring back to, he had no rental apartment, he had no apartment to live in, and the like. So that's what I'm drawing from your argument. So let me ask the question then. Are you suggesting then that the only way to establish, let's say you had a job in D.C. or you had a job somewhere else where you went off for a period of time, that could be 5, 10, 15 years, whatever it could be, right? Are you saying that you must have a contractual relationship to bolster the case for residency?
No, I'm not saying you have to have that. I'm saying it's a totality of all of the case, all of the elements, all of the facts of the case. So, for example,
So if he had a contract here, if he had a sublease to his parents to that bedroom, you'd be okay?
not necessarily. It depends on the facts. That would be a fact that would weigh in his favor. Here, let me show you another fact. I cite a case in the papers that I filed where an individual, grown man in his 20s, claimed that he was covered by his parents' auto insurance when he got in an accident. But he had an apartment outside of town that he lived in. He leased it, he lived there. The insurance company said, no, you're not covered by this because you don't reside in your parents' house anymore. In this case, there's a
different standard on
Right.
insurance policy.
Well, there's in the file, there's evidence from the parents' insurance policy. They have a State Farm insurance policy on their automobiles. And during the window when he was in Washington, D.C., he was specifically excluded from their policy because he didn't reside there.
Because
So-
they wouldn't be using the vehicle.
Right.
No, but he went home for the holidays and stuff and used the vehicle. But he was,
You know,
it was
I-
explicitly.
Yeah, I hate to say
excluded.
this, but I mean, and I'm drawing from my own personal experience, but you don't have to have, I found your child on your insurance policy, auto insurance, he's automatically covered. So and I know that's outside of the record, but.
Yeah, but the difference is that this candidate in this instance was specifically excluded there's different coverages,
Yeah,
right? If
because
someone borrows your
it
car,
could-
they're covered, right?
Because it could cost more on
Right,
your insurance. So
right.
I excluded my son, right, but that doesn't mean that he can't have access to the car.
No, my point is that you can't be covered as a household member if you don't live in the household. And so the standard that the hearing officer adopted is he can't get auto insurance at this house, but he can run for an Illinois constitutional office?
Because, as I understand it, the standard is, did the candidate show intent to permanently abandon residence in the district?
Right.
Now, you are saying, well, maybe because he lived elsewhere, we can infer that he did that. I'm looking for evidence that he showed an intent to permanently abandon, not just, I'm gonna live somewhere else for a while and, you know, and maybe go into a PhD program. I'm abandoning my residence in Illinois.
Right, and he did that by accepting a full-time, permanent job
Other
in
than chief
Washington-
of staff at the White House.
in Washington DC without his own connection to the representative district.
I kind of want to move to Mr. Finko, and unless there's something,
No.
no, okay, thank you. Mr. Finko?
Thank you. The issue here is that the Constitution defines the eligibility. The Constitution defines eligibility. There is no provision that says be like Rom in the Constitution. There is no requirement for property ownership, and there's no millionaire requirement or other requirements other than the residence. And the residence is evaluated based upon the factors that are discussed in the Maxon case. And the Maxon case clearly says that once residence is established, then it remains there until abandoned, and the absence for months or even years, if all the while intended as a mere temporary absence for some temporary purpose to be followed by a resumption of the former residence, will not be abandonment. And that's the Kresse versus Berensmeyer case from 1888 that was cited in the Maxon case. The insurance case, State Farm, is first of all from Texas. I think right away we've got a different world we're talking about. So that's a question about the reliability, and it's similarly a question of contractual interpretation rather than the election code. I think the similar case would be the People versus Baumgartner case, in which a candidate was in Moultrie County. His family had a farm there. He went to U of I to start with his bachelor's. He met someone, he continued on with his master's, they got married there. They bought a house in Champaign County. They continued to live and work there. But the important things, I think, were pointed out by the appellate court. He maintained his driver's license in Moultrie. He went back to Moultrie where his father's farm was, helped out and visited. He maintained his voter registration at the father's address in Moultrie on the farm. The candidate herein took a similar approach, and he testified. He went to Washington for experience. The first two internships he received were specifically tied to his master's degree. And he was in DC for those two internships, which were 3 months, and then one was extended, so it was a 4-month. He submitted his final paper in December 2015 in order to attain his master's, which was given to him some point thereafter. He explained at the hearing that he wanted to get policy experience. The two internships that he had did not offer that. So he tried for another internship, and it was, he went with the senator. That helped him, but it didn't quite fill his need for experience. He went on to Bureau of Labor Statistics. Again, that's a great agency, but it didn't have the policy end, which he was looking for. He went to the Senate, and he says that's where he found the policy experience that he was looking for. In 2018, he made the decision that he would be leaving in 2019 to run for office. He entered a shorter lease, not a 1-year lease. It was a 10-month lease that ended August 2019. He put in his resignation, came back to his home in Burbank. The facts do not indicate any permanency or intent. None of the facts indicate permanency or intent to remain in DC. Sure, there's some differences. He was 25. There's a 25-year age difference between when Mayor Emanuel ran for mayor and when Ricky Gandhi's running, approximately 25, when he's running for representative. He has not acquired the Wall Street experience yet. He hasn't gotten the millions of dollars yet. So no, he hasn't been able to buy a house. But that's not a requirement in any world anywhere. And it's a fact that does not exist in this scenario. He does have a permanent residence though, and that's the important thing. He has keys, he He has a place to sleep. He keeps his things in Burbank. He's always maintained the Burbank address, and everything he's done has been a temporary absence in DC solely for purposes of getting experience. The PhD was something that he thought about when he was 22 years old. Okay, he was, in 2014, he was 22. So I think the arguments here do demonstrate that the times are changing. There is a difference not only between the current younger folks facing different challenges, different financial hurdles, different obstacles, and they are finding their own way to get through those. I think there was also an issue that in this situation, Reiki Gandhi has a strong cultural family bond, and he says in the Indian culture there is a tradition that families stick together in the same home, and they often live in that home for extended periods of time. So I think it's not appropriate to criticize a younger person who does not own a house yet, or has not yet made millions, or hasn't done the other perhaps things that somebody in their 50s would have achieved. The Constitution is clear. The residence issue is clear. Hearing examiner's recommendation examined all the facts, and the case law does say that it's a fact-specific inquiry. And in this situation, the hearing examiner's recommendation is the proper one. Evaluated all of the facts, all of the testimony, the documents, the voter registration here in Cook County, the driver's licenses here in Cook County, and all of the ties. And I believe the residence was appropriately recommended, and I would ask that the Electoral Board overrule the objection and issue a findings and decision that the candidate's name shall be printed upon the ballot. Thank you.
Thank you.
Briefly?
Yeah, do you want briefly?
The internship, no problem, right? A young person goes for a 3-month internship, 6-month internship, whatever, a fixed period of time. That's similar to Mayor Emanuel and the White House Chief of Staff. He said at the time, I'm going to do this for no more than a couple of years, then I'm going back to Chicago. There's no corresponding evidence of his intent to return to Chicago. The only evidence is that he got a permanent apartment, that he leased an apartment for a year, then he re-upped his lease, and then he got a full-time permanent position. And nobody came forward and said, oh, he told me he's going to do this for a year or two. It's very different from Mayor Emanuel, and this is a slippery slope. If you find that this person is qualified for the ballot, then every person who seeks office is going to be able to say, I live at my parents' house. And that is simply not the law. At some point, the cord gets cut. And the evidence here shows that this man left his parents' home and moved to Washington, D.C., where he was a full-time resident for a number of years. And had he returned, had he not re-upped with the U.S. Senate before the window opened and come back then, he'd be qualified. But he made the decision to keep his permanent job. He made the decision to renew his lease in Washington, D.C. That renders him ineligible. The objection should be sustained.
Thank you. I think we all have reviewed the hearing officer's report, and I frankly, and I understand the slippery slope issue, but I think it's very fact specific. I think each of our hearing officers look at that very carefully, the home issue. But in this case, I agree with the hearing officer's decision and the facts that he points to in holding that the candidate did have, was a resident. And therefore, is there a motion to deny the Rule 20 motion?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Thank you.
Thank you.
We will now proceed with final off the record for Ryan.
Thank you.
Hey, look at these two. I gotta get brown shoes. Jeff?
We're back on the record. We will now address hearing officers' reports and proposed final decisions.
Madam Chair,
Yes,
I would move that for the case designated number 11, case number 20, EBWC 007, Quintela Benson and Ava Thompson versus Anthony Beal, that I move the chair to table.
is there a second?
Second.
All those in favor?
Aye.
Okay. Now we will, thank you. Now we will proceed with the cases, and I will be taking some of the cases out of order in order to address them in groups. The first one is Mary D. Olivo versus Jacqueline Baez, 20 EBWC-019. That's number 14 on the agenda. In this case, the candidate submitted a notarized withdrawal of candidacy form on January 3rd, 2020. Is there a motion to accept the candidate's withdrawal?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and this case is dismissed, and the name of Jacqueline Baez will not be printed on the ballot for the election. The next group of cases is where the objections have been overruled. The first one is Tracy Jennings versus Craig Cameron, 20 EB-CON-001. That's item number 1 on the agenda. Renee Soto versus Alicia Elena Martinez, 20 EB-RGA-001. Number 2 on the agenda. Ida D. Walker and Anita Archibald versus Nicole Nikki Harvey, 20 EB-RGA-006. Number 3 on the agenda. Deborah Murphy versus Nicole Nikki Harvey, 20 EB-RGA-007. Number 4 on the agenda. Ida B. Walker and Anita Archibald versus Sandra Schneller, 20 EB-RGA-010. Item number 5 on the agenda. Melissa M. Josephs and Bradley W. Lippitz, 20 EB-RGA-011. Number 6 on the agenda. Andre Papetti, 20 EB-RGA-019. Number 9 on the agenda. Veronica Ramirez versus Daniel Laspada, 20 EB-WC-005. Number 10 on the agenda. Renee Soto and Virginia Contreras versus Alicia Elena Martinez, 20 EB-WC-010. Number 12 on the agenda. And Raymond A. Lopez versus Edgar Flores, 20 EB-WC-012. Number 13 on the agenda. Is there a motion to adopt in all of the above matters the respective hearing officers' reports and recommended decisions, overrule the respective objectors' petitions, and enter final decisions in favor of each of the aforementioned candidates?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and the motion to adopt the hearing officers' respective reports in the aforementioned cases is granted, and it is therefore ordered that the names of the respective candidates shall be printed on the ballot for the primary elections. The next group of cases is where the board has determined to sustain the objections. First one is Geraldo Morgan versus Tawana J., aka T.J. Robinson, 20 EB-RGA-015, number 7 on the agenda. Marlo Barnett versus Tawana, aka T.J. Robbins, 20 EB-RGA-016, number 8 on the agenda. And, is there a motion to adopt the hearing officer's report and recommendations and sustain the objections?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. The hearing officer's report and recommendations is adopted. The objector's petition is sustained. It is therefore ordered that the name of Tawana J, AKA T.J. Robinson, will not be printed on the ballot for the primary election.
Madam Chair and Commissioners, I have members of the board final decisions memorializing the actions that the electoral board just took. I'd like to remind the world that Section 10-10.1 of the Illinois Election Code, these documents will be served on the parties today through regular mail. So that parties in the room for case RGA 19, they can be served personally here, which then starts the 5-day clock for filing a petition for judicial review.
In the meantime, I have not received any requests for public comment. Is there any requests for public comment? Decisions have been signed. And is there a motion to recess at the call of the chair?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
We'll recess.